Welcome to Sakshi TV's special immigration show with attorney Sheela Murthy from the Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. Eastern Standard Time with attorney Murthy, Wednesday at 5:30 p.m. Eastern Standard Time with attorney Prashati Reddy in English, and on Friday at 6 p.m. Eastern Standard Time with attorney Banu. Please tune in to ask your questions. If you're an immigration attorney and would like to join our immigration show, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not official legal advice. It is for general information purposes only. Sakshi TV nor its agents will be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy, thank you so much for joining us today.
It's such a pleasure and honor to join all of you today. Thank you for the invitation and the opportunity to help and enlighten and educate and hopefully inspire people to doing more.
Of course. So can we get started? Would you mind providing our viewers just a bit of information about your law offices, your practice areas, and your experience?
Sure. So the Murthy Law Firm was started over 26 years ago in 1994. And all we do is focus primarily on employment-based immigration, H's and L's and green cards and all of that, plus family, somebody marries, students, F1 student visas, all of those different categories. And we have a total staff of about 100 people here in the United States, about 30 people in India. And basically for people in India, for those who are stuck with problems with US consulates, where they are not able to get the visa, there's a delay or a denial of some sort, unfortunately. And we have a team there of lawyers and staff that works on that. So that's a very, very brief overview of the nature of the practice when we started. My own background, of course, is I've been practicing law for over 30 years, focusing, of course, on US immigration law. Like many of our viewers, I had to go through the personal process of getting my own immigration and did not have a very positive experience, unfortunately, with that. And so decided that I was going to start a law firm where our main focus and goal was to help others, genuinely take good care of others, help them, guide them, mentor them, and educate them, as we do through the award-winning website, murthy.com. That's www.murthy.com. And basically, we have like a free weekly forum. We have daily about 1.5 lakh people or 150,000 subscribers. We have lots of people exchanging information, the forum, the weekly Murthy Bulletin articles. We have live question and answers with lawyers answering it. So there's a ton of valuable free information that we provide. Our goal genuinely is to help educate, mentor, inspire, enlighten people so that they don't feel alone in the journey of their US immigration processing, because it can be very complex and very overwhelming for many people.
Excellent. Thank you so much for all of the advice that you're going to be able to provide our listeners today. I know they appreciate it. But let's get started with today's topic. So I know we're particularly interested in the new regulations or modifications pertaining to the H1B, specifically replacing the H1B CAP Random Process with wage-based process. Would you mind helping us understand how to register under these new regulations?
It's an excellent question. The catch, of course, is that the government has not released the entire process altogether. They've certainly said that they're going to change how they're going to select cases in the random lottery process. So what they've done right now, which obviously is under the current Trump administration, is they've issued final regulations which have to become effective presumably on March the 8th of 2021. But of course, we all know that on January 20th of 2021, the Biden and Harris administration is going to take over from the Trump administration. Since we are in the 60-day implementation, because the regulations cannot become final for 60 days, and that's the date in March on March 8th that it's supposed to become final, Joe Biden has made it clear that he is going to possibly put a hold on what they call the midnight regulations, all passed in the 11th waning hours of the Trump administration. And so Biden really has 2 or 3 options. One of the options is put everything on hold for 60 days from the day when it was to become effective, which means that of March 8th, the regulations becoming final, it could be March 21st, which would be 60 days from when they issued the from the day that he becomes the president. Or it could be from 60 days from the day it was supposed to become finally implemented, where instead of March 8th, it could then become May 8th of 2021. And then the third is, of course, if there's going to be potential lawsuits and litigation, which we very well expect, then everything would go on hold, basically. So there's all of these different permutations and combinations that could exist. Now, for all that Biden has said that he's not going to tolerate all those presidential proclamations that have prevented H1s from coming into the country, et cetera, which Trump has now extended from December 31st of 2020 till March 31st of 2021, even though he's no longer president, he has extended it. Those Biden has made clear that he's absolutely planning to roll back many of those. But with respect to wages, even the Biden administration has been somewhat concerned that during this COVID-19 climate, we do not want to be in a strange, funny, weird position where foreign nationals could come and take away American jobs or depress the wages and working conditions for Americans. So that's where we're a little concerned and not sure how they plan to approach it. Will they look at it 30 days from the day the final regulations were implemented and become effective 60 days from the day of the final? Or will there be a complete halt, or will there be some other modification? But whatever happens, our biggest concern, of course, is that for this year's filing, for the H1s to become effective from October 1st of 2021, which usually we file them around April, May, June, July in the summer. Well, we don't know that there's going to be sufficient time unless we know what is the specific criteria under which they're going to be approved. We know that under the current regular final, interim final, now the final regulations, they plan to pick those with wage level 4, and then it descends to wage level 3, wage level 2, and wage level 1. And if somebody isn't using the OES wage data, they're going to take them to the lowest level of wage level 1. So I think there's so many unknowns, so many scary things, because how can people know what exactly they're filing if they don't know what the rules of the game are going into filing before the H1B CAP season?
Absolutely. Wow. You've touched on so many important points. I have more questions on that, but we do have a caller. So let's go ahead and welcome our first caller.
Maybe the person is on mute. Are you on mute? You want to unmute yourself?
Yes. Is our caller here?
What's up? Hello.
Yeah, we can hear you. Just go ahead and speak up.
Okay, I'm calling from a company, ma'am. I have a couple of questions. First thing, while filing the LCA, when we say we had an employee who was working with us for almost 4 years, and she got a full-time, she left us, and she's coming back. So when we are opening an LCA, how do we mention on the LCA? Do we mention like a rehire, or because we are rehiring her, but how do we mention?
Generally, it's just a new hire, because even if it's a rehire, that's considered a new employee. It's either an existing or a new. So you just need to make sure, check the different check boxes. Again, we can't get into specifics because by law, we're not permitted to do so in a discussion like this. But you need to look at the form, look at it, and see which are the different options and which one would most accurately fit the person. Presumably, you have a company lawyer or somebody on your team that's working on immigration-related issues. Make sure, because
we have an in-house team. So we were working with in-house team. So
no, I didn't understand. You're working with a what team?
Like we have an in-house immigration, like, a couple of people who was working, and we take suggestions from an attorney. But when we are doing an LCA, we have just this question. So we usually file the applications within the office.
I see. Okay.
So because
Well, it's
because we
usually
already have
considered
like
a fresh
two.
hire.
Yeah, we already have two extensions filed for her in the past. So because when we say new hire, do we pay the like $4,000, which is the public fee, or no?
So it depends. If you're doing it as an extension case, maybe you can request an exemption. In some cases, if you haven't revoked the prior H1 petition, you could certainly try to see if you as an employer have not revoked that H1 petition, it still remains valid, then the employee could presumably continue to work on that previously approved H1 petition if it still remains valid and has not expired
No,
under the terms of and the dates and the validity periods here.
no, it's been expired, ma'am. So it's been expired like somewhere around 2019, and after that she got a full-time job, and she was in a full-time job, and now she wants to come back to us. So we had a project for her. So we want to open an LCA. So in this situation, do we go with new employment? If we go with new employment, do you pay the public fees of $4,000, or we can do for like change in employer?
Yeah, it's often you can do a change in employer if it's so. This is where we can't, as she said up front at the beginning, without looking at every nuance of the detail. We don't want to start giving case specific advice, because if there's an exception to an exception to an exception to something on the form or something in the paperwork that we may be able to analyze it and look at it differently, we don't want to be saying this is exactly how to do it. But certainly if you could just try to figure out if there is a way to minimize that 4,000 or eliminate that 4,000 fee, obviously you want to sit down and work on it. You don't want to be penny wise and pound foolish, where you're trying to save a couple $100, not speaking to a lawyer to look at it specifically for you, and then lose $4,000, because that would not make any sense, right?
Yeah, that's why I wanted to take an opinion, but because I was going with your show, so
No,
just
we
I
can't
wanted to
give
ask this question.
legal opinion. This is not a
No,
legal
I
opinion. This is
completely
more
understand. Yeah,
general information.
yeah. And I have one more question on the same LCA, the same how we choose it. When we say concurrent H1B, so can a same employer file a new concurrent H1B for the same employee? Like he had one job with employer A, and the employer A had other job for him. So he's okay to do two jobs. So when we are opening an LCA for the second job, can we use like a new concurrent employment?
Generally, new concurrent employment is concurrent employment with a different employer. If you're saying the same employer, company A, is doing an H1B for the same employee, but on project X and then project Y for concurrent employment, and you want him to work 20 hours, for example, or her to work 20 hours in each job, potentially you could take it. Generally, I know that the way the regulations and everything was, when it says concurrent, it's usually a separate employer, a new employer, H1B petitioner, that is used for concurrent employment, because otherwise it would technically be an amendment that you would be filing for the employee. And if you're saying that the person's going to work 50% on this job and 50% on that job, then you would do an LCA for both locations and then file the petition, but it would not be concurrent employment in that situation.
So here, because you mentioned one LCA with two locations, as he's working two jobs. So coming to the whatever we pay, we have a rate range or coming to the LCAs. So because he's doing two jobs, so suppose the job one has been lost. So we have opened an LCA with two jobs, and his amendment got approved for 3 years. Later on, he lost one of the jobs. So, but he still continues the second job. So, do we still need to do an amendment? Where if there's a site visit going on the other job which he has lost. So
yeah, again, because we don't want to get into case specifics, but as a general rule, if the person's lost one of the projects, then you might want to revoke that particular. If you did it, say that this project is no longer valid. If it's on the same H1B petition, it was an amendment and you're going back to the original work location, then you might be able to say this amendment is no longer applicable. The person is going back to the original location as mentioned on the original H1B petition, for example.
In the amendment, we have mentioned two different locations. So after the two different locations, one location he's been out of the project. So there is other location which is still active. He's working there. So we still have to notify them that one of the location is no more working there, or do we have to do
So
a
if
new
you
amendment?
wanted to give him 20 hours in now a third location, then you would do the amendment again, mentioning location A, and instead of B, now you're going to mention location C for the employment.
Okay.
So you would then do the
So if there's
amendment
only
for
one location, ma'am. So if there's
if
only
it's only
location
one
A, because
location and you're okay, and your original H1 said that he can work, if you said it was only 20 hours location A and 20 hours location B, and now you want to make it 40 hours in location A per week, then you are required to do an amendment because you've now switched it again, potentially, unless you said that it could be either or, and you were broad enough and you were wise enough when you completed the first one, knowing that this could occur, then you could very well say that as mentioned in the original H1 petition, if ever you get an RFE or a request for a denial or something, you can say from the beginning, we had said he's working half and half, but either location, he might be able to move full time. And if there are changes from either of these two locations or both of them, then we would file an amendment only in that case. So if it was done in a manner initially to cover everything properly, then you might be safe. But again, without looking at the underlying documents, I'm not clear how it was filed.
Okay, I'll definitely make an appointment. But one more last question, because just to end up my last question. In the LCA, we never mention on location one how many hours or location two how many hours. We just mention the rate, whatever it's hourly, weekly, or monthly rate. So there's nothing called specific hours we mention. So even if it's like if I give a monthly range in the locations or weekly range, if I mention while taking an LCA and two locations, if I'm paying two different way, whatever the weekly or monthly rates. So is that okay if it's like, both are above the minimum wage level and if I'm paying him both the rates, or is it something I have to pay only location one or location two?
Right. So if for location A, the salary, let's say, is $50 an hour, and location B, the salary is $60 an hour, example. So now if he's only going to work in location A, then $50 would work. On the other hand, if he's only working in location B, then the minimum salary would have to increase to that $60 an hour instead of $50 an hour. And so if you didn't mention anything and it was sort of vague and you believe that it's protected and as the employer, you had done a very complete, clean, safe case, then you might very well be okay with not having to do an amendment of any sort. But again, that's something that somebody would actually need to verify, and you would need to double check and have the lawyer confirm that in fact you are completely protected the way the petition was initially filed for it to work in both location A and in location B.
Thank you so much, Attorney Murthy, for that. We do have another caller. This caller is from Texas.
Hello.
Hello.
Hi there.
Hello.
Welcome to the show.
Yeah. Hi. Good afternoon, ma'am.
Good afternoon.
I'm an employer representing an organization. We are basically into software and consulting. So I have a couple of questions here relating to the new H1B, which is going to happen. So unfortunately, the rules are not yet out, like how the registration process is going to be. But based on your experience level and the changes you have seen from many years into immigration, what do you actually advise the employer, considering the new administration and the new filings? And the second question is, we have, they mentioned saying that the random selection process is going to be changed based on the wage levels. So do you advise us, all the major consulting companies to go and file on the level 3 wages? If in case we file the level 3 wages, what would be the consequences in regards to the RFEs when it because we have to check the roles and responsibilities and everything when we put on the level 3 wage. So what would be your general advice, like how the filings should be done?
So obviously we're saying everybody's waiting, watching, monitoring. We hope that before the end of this month, we'll have a much better idea whether Biden has put a temporary hold or a permanent hold or what kind of a hold on the continuation of these regulations and whether the effective date will in fact be March 8th or May 8th. Because if it is May, then it's not going to be, they won't become effective for this coming year's filings. It may become effective for next year if it is not going to be completed March or April, because as you very well know, most of these, the forms and the paperwork and the information, all of that is pretty much, we start filing the petitions, and it's a lot of this is being done, the pre-registrations are being done in the month of March. So it's going to be very, very tight. So we're telling people we should know one way or the other what's happening. You have to assume everything's going exactly as it is, but you don't want to be paying, in your example with your second question, you don't want to start giving level 3 wages if that's not what you're actually doing with your employees, because of course you're signing all these documents, as you well know, under penalty of perjury. So presumably then you're providing accurate and correct information. And under these final regulations, they have said that if you are relying on not the OES wage data, but on some other independent authoritative source, then they're going to possibly consider that as equivalent to level 1 wage, even if you're saying it's a level 3 or a level 4 wage. So, and they've even said in the same regulation, the final regulations, that we expect no level 1 wages to be selected or to be processed and to be approved for the fiscal year 2022 H1 quota. So, I hope that answered all of your questions, but the bottom line is at this point, if you're looking for 100% clear-cut guidance, I don't think anybody in the country can say it's going to be A or B, because we are just waiting and watching, and well before you file it, you should know whether we are now going to be subject to the new regulations because they are going to become final and hence effective for this year, or whether everything's going to be on hold. Our hope is that most of it will be on hold because multiple lawsuits had already been filed. And in fact, they got 1,400 comments on these final regulations. And in any other administration but the Trump administration, something like that would have resulted in delaying it or in changing or modifying it, but there wasn't even a small change made from the interim final regulations to the final regulations under the Trump administration. Thank you.
Perfect. Thank you so much, Attorney Murthy. Just quickly, I want to go back to the conversation that we were having before regarding the new regulations or modifications pertaining to the H1B. Organizations will be working with Immigration Counsel for this upcoming H1B CAP. Will they need to set up an account in the US CIS registration system?
So the entire process is every single case has to be registered like it was in last year. They started this only from last spring in 2020, which was obviously a terrible year with COVID-19 raging, the economy swaying and employers laying off people or dealing with a whole bunch of stresses that the likes of which the economy hasn't seen, the US economy, in over 100 years. So every single employer would need to pre-register the case so that only those pre-registered would then be selected for being processed so that they can send in the H1B petitions. That's how it worked last year. The goal was to continue that, except now they've thrown another spoke in the wheel, stuck another spoke into the wheel by now introducing these brand new final regulations to completely overhaul the system in which they are going to process or accept cases for registration by saying we are going to give the highest priority to a level 4 wage and then a level 3 wage and then a level 2 and then a level 1. And we expect nobody in level 1 to even get picked or selected in the lottery. So does every case has to be pre-registered? Yes. Would we be subject to the new rules? Just as I said to the person right before this, we are hoping that we will be able to use the rules, because remember one more thing, nowhere under the law can the executive branch completely change what the legislative branch or the US Congress had said in the law. The law itself nowhere provides for a brand new, completely different criteria to be established for processing H1B petitions. It is supposed to be It shall be by a random lottery process. If we get more H1 filings, then there are numbers available in the quota system. So the Trump administration pretty much coming up literally out of thin air with completely new requirements using COVID-19 and the economy as the reason makes no sense, because the law doesn't allow you to completely overhaul the legal criteria under which H1s can be awarded under the law, which is why we expect legal challenges and either temporary or permanent injunctions, because it's all of what's being done is just being done without properly going through and following the law itself.
That makes perfect sense. So is it safe to say that if an organization has multiple entities, that they would need to set up a separate CAP registration account for each entity then?
Each entity that has a separate federal tax employer ID number, or FEIN, each entity that has that works, has a different either address or what have you, if they're different entities, legal entities, they would need to set up a particular and the government, the USCIS has also said, if they're related entities, you cannot file multiple H1s for the same candidate if they are sister concerns or working off the same end project, et cetera, because they didn't want too many people trying to get those limited slots of H1Bs by creating multiple parallel companies for the same candidate.
Absolutely. And I know there's a bit of confusion and waiting in terms of the new regulations versus the old regulations, but when can an organization start creating accounts considering these new regulations?
You can always create your account whenever, as soon as they open up the registration window. And there's a tight time frame. And if you file all those cases, what they did last year, for example, because of COVID-19, they did not get as many, they shut the window for filings, and then they realized that there were still quite a few unused slots. So then they opened up a second lottery, but it was still based on the initial filings of that initial cutoff date. And then they sent out a notification to employers to be able to file for their employees in the second go around.
Excellent. Well, unfortunately, we are out of time. This show, I know it flies by, doesn't it? But we are looking forward to seeing you again. If you're interested and have more questions for Attorney Murthy, please join us again next Tuesday at 3 p.m. Eastern Standard Time. And Attorney Murthy, if you wouldn't mind also just sharing your contact information for the viewers.
Sure, it'll be an honor and a pleasure. Again, the website is www.murthy, M-U-R-T as in Tom, H-Y.com. The email is law@murthy.com. And as I said, please feel free to sign up for all the wonderful, free, valuable resources available on murthy.com, like the free weekly bulletin, the free forum, the chat, all of those fabulous resources so that you can continue to stay engaged and learn of these crazy changes. A lot of our summary of what we discussed is already on the website in different places. And every day that we are seeing new changes in the law, it's all out there on murthy.com. I really wish you much success. And I want to wish all our viewers and you a very happy new year. And I really hope that 2021 gets us good health, a COVID-19 vaccination, all your immigration problems solved, a new administration and spring round the corner. Thank you and stay safe, everybody.
Thank you. And we'll see you next week.
Thank you. Bye-bye.